The opening remarks for this particular session are being made by Honorable Mr. Justice Arun Monga. Justice Monga joined the bar in the year 1991. It was in the year 1997 that he shifted over to Delhi. He was elevated in the year 2018. During this bar journey of Justice Monga, he had the corporate clients and other matters before the different courts as such. His long innings at the bar were covered within the board rooms and the court rooms, and the way he performed, I'm conscious of that. And he brings in rich experience in that context. Equally, after having been elevated to the bench of Honorable Punjab and Haryana High Court in the year 2018, his contribution is unique in various ways, and particularly his expertise in the field of technology is being acknowledged across. Technology challenges, as Justice Monga has already put in the beginning itself, for that matter. Well, these are the challenges that we are facing, but particularly in the family court matters, the role which technology can play and those challenges, how do we meet about them? That's the domain of this particular session. I would request Justice Monga to kindly make the opening observations, give the roadmap so that we proceed further with this particular session. Over to Justice Monga.
Good afternoon, everyone. So the topic goes challenges of digital technology in family justice system. In fact, just before I was introduced, informally, I was speaking to Dr. Gupta that in fact, the digital technology has rather made family justice system less challenging than before. Most of us will know that one of the earliest video conferencing was in Supreme Court in a transfer petition that was regarding matrimonial matter. It was a case of Madhya Pradesh High Court, and much before the pandemic struck, nobody at that time envisaged that video conferencing could be an easy way out. The lady had to travel some 700 kilometers in what was an open and shut case. Eventually, her transfer petition was to be allowed. So in that, in fact, the ball was set in motion, and thereafter much water has flown, and it's like really gone way ahead. And then thanks to pandemic now, it's become a completely changed scenario now. So much so that in High Court, we have amended our rules. We introduced new rules with regard to video conferencing post-pandemic. In fact, if Justice Chandrachud has his way, soon we might even have live streaming of the court proceedings, in which case it will become all the more, I guess, totally a routine to be participating, especially in family matters, especially, let's say, for example, at least the mutual consent matters, where all you have to do is ensure that party's identity is, as long as identity is ensured, it's a very, very formal process, we all know. So in terms of challenges, I guess the challenges are perhaps even now, sometimes serving the parties overseas. In fact, because as we know, in private international law, people have parallel jurisdictions abroad and here, parallel matrimonial proceedings going on, etc. So that is one of the challenges where we have to perhaps meet our digital requirement as to should we accept, though of course there are enough judgments of Supreme Court, even our own High Court has given view, many other High Courts have, Delhi High Court has come up with the formal, in fact, amendment in the High Court rules saying that service is possible through WhatsApp and email and every mode. Even CPC has mandated. But the question is when there's no blue tick. No, there's a judgment of Supreme Court saying as long as there's a blue tick, it should be presumed to be served and party can proceed ex parte. Now, people are smarter these days. They can switch off their blue tick, especially when they know matrimonial proceedings are going on interstate. So they'll make sure that. So these are some of the challenges perhaps we have to meet. So in that case, should email be taken as a conclusive proof of in case it doesn't give you bounce back report? If it doesn't get delivered, the email bounces back. So can the presumption be drawn? But recently, Justice Jayashree Thakur has said that as long as you give a screenshot of a delivered email, even that would be presumed to be service. So I guess wherever there are gray areas, the judgments are filling it up. So with that, I guess since I'm just supposed to give the opening remarks, all I can say is that with today's digital world, things have become much more easy, especially for dispensation of the matrimonial disputes. One can easily go ahead taking advantage of digital technology. In fact, ones who are approaching the court, everyone has a cell phone. Everyone can join through video conference, especially in mutual consent matters. Of course, mediation is a challenge where people need to have that face-to-face interface. Without that, sometimes it's just not possible to mediate through video conferencing. But maybe one can at least minimize the travel. You don't have to come for every meeting. Maybe the conclusive meetings can be in person, and it can be part VC and part physical. Well, with that, I think I'll hand over to Justice Ram Gupta, since I'm just supposed to give opening remarks.
Yes, thank you so much, Justice Monga. You know, it's always inspiring to hear you, and you focus the issue so well today. We proceed further with this particular session. Very kind of you to have spared your time and be with us for the opening remarks.
Thank you so
this
much.
Session is being taken.
Leave, Dr. Gupta, and thank you so much for honoring me to give the opening remarks. Thank you so much.
Kind of you, sir. Very kind of you.
Thank you, everyone.
Thank you. We have today with us Harshali Chowdhary. You know, she's a part of the Chandigarh Judicial Academy faculty. ADJ since the year 2018, with a good, strong academic background. But I would particularly like to mention about her. She is the IT person who is looking after Chandigarh Judicial Academy, in particular, along with the various other academic activities that she is participating in. She is making a contribution. She came to us in the year 2021 and contributing to the academic health of Chandigarh Judicial Academy. She is the right person to focus on the challenges of digital technology in family court system. May I request Harshali to kindly proceed with this session and show us the roadmap how we can make use of technology in family court matters. Over to Harshali.
Namaskar. Thank you very much, Director Sir, for your kind words of introduction. I also thank Chandigarh Judicial Academy to provide me with a forum and an honor with this opportunity. A very good afternoon to your Lordship, Mr. Justice Monga. It's indeed an honor and privilege to have your views on this ever-developing area of law. Also, I pay my regards to the esteemed participants for their keen audience. The topic that I shall be dealing with would be challenges by family justice system in the era of digital technology. This topic shall be dealt in three parts: challenges in service of processes through WhatsApp or email, admissibility of electronic evidence, use of audio, video conferencing in family justice system. Before I start with my session, I would like to have a disclaimer that law pertaining to digital technology, either judicially or at administrative side, is still at a nascent stage. We have more questions than answers. Challenges are more. I may not have lots of answers to the burning questions on digital technology vis-a-vis family justice system. However, I shall make the effort. Spirit of the argument is to be kept in mind, and harmonious construction is to be given with available avenues and a strive to look out for solutions. Starting with the first issue, it is with regard to the appearance of the persons through some.
पहले तो आप किया करते थे बारे में
नहीं सर मैं आपके पास भी नहीं रहा मेरे लिए
Now, starting with the first issue, it is with regard to the appearance of the persons through summons. Now, the first aspect of the service would be what procedure is to be adopted by the family court for effecting the service. Section 10 of the Family Court Act says that for the suit and proceedings in the civil matter before the family court, procedure laid down in CPC would be applicable, and the family court shall deem to be a civil court. For the criminal matter, procedure as laid down in Code of Criminal Procedure would be applicable. Subsection 3 of Section 10 further speaks that the family court may adopt its own procedure with the aim to effect settlement between the parties before it. Now, Honorable Punjab and Haryana High Court framed Family Court Rules 2005 in view of the powers under Section 21 of the Family Court Act, by which under Rule 12, provisions were given to effect the service of processes as per Civil Procedure Code where civil proceedings are concerned and Criminal Procedure Code where criminal proceedings are concerned. For effecting the service in the criminal proceedings, we have Section 61 to Section 90 CRPC, which give out the provisions to compel the presence of the person before the court. Now, these provisions can be resorted to procure the service of the persons, let's say in maintenance proceedings or execution proceedings before the family court. For effecting the service in the civil proceedings, we have in particular Section 27 to Section 29, Section 31 and Order 5 CPC. On the perusal of these provisions that we have, there are no such detailed provision which empowers the court, let alone a family court, to procure the presence of the person before the court by adopting digital technology. However, the judge-made law, which is available before us, by which the service of the person is sought by adopting the methods like email, WhatsApp, show that the courts have now gradually started adopting the digital technology, which is fast, cost-effective in procuring the service of the person. Now, in the year 2004, Honorable Bombay High Court, in the case of KSN Industries, while disposing of a case under Section 138 of Negotiable Instrument Act, showed its concern with regard to the delay in procuring the service of the accused. It was observed by Honorable High Court that courts must adopt pragmatic approach in procuring the service of the accused, which includes sending the mail to the accused on the email provided by the complainant. Later in the year 2010, in the case of Central Electricity Regulatory Commission, Honorable Supreme Court also laid emphasis on the usage of email, fax, etc., to procure the presence of the parties. It was in the year 2011 that Delhi Court Service of Process by Courier, Fax and Electronic Mail Services for Civil Proceedings Rule 2011 were framed for the High Court as well as the subordinate court to affect the service on the person before the courts in civil proceedings by way of email. Later on, again, Honorable Supreme Court in Indian Bank Association and others in the year 2014, while disposing of a case under Section 138 of Negotiable Instrument Act, emphasized that magistrates should adopt a pragmatic and realistic approach while issuing summons. Summons must be properly addressed and sent by post as well as email address got from the complainant. Honorable Bombay High Court also framed its rule for affecting the service in the High Court in commercial dispute cases as Bombay High Court Service of Process by Electronic Mail Services Civil Proceedings Rules of 2017. Honorable Delhi High Court also in the year 2017 in Tata Sons Limited allowed the plaintiff to serve the defendant by text message as well as through WhatsApp as well as by email and to file the affidavit of the service. Now in the year 2018, again, Honorable Bombay High Court in the case of Dr. Madhav Vishwanath Dhaval Bhakta emphasized that under Order 5, Rule 20 CPC, which is for substituted service, by invoking Sub-Rule 3 gives the option to the court that the summons can be served in such other manner as the court thinks fit. Thus, the manner in which the court opts should be akin to the earlier mode of service which is mentioned in the rule. For this, the court can take into account the modern ways of service which are available due to internet connection. It can be served also by courier or by email message or by WhatsApp, etc. However, the court should be satisfied about such service. Under Chapter 7, Part B, Volume 4, Rule 1.3, Punjab and Haryana High Court Rules and Orders, wide correction slip dated 27th of November 2018, the service of the process to the other party is allowed through electronic means where the parties have furnished requisite details. Now, year 2020, when the entire world was hit with COVID-19 pandemic, justice dispensation system was also not left untouched. It was in the year 2020 that Indian justice system actually ushered knowingly or unknowingly, with preparedness or with not so much preparedness, into the era of digital technology, whether it was for the service of the parties or for the filing of the cases or for the usage of audio or video conferences. Now, in reference cognizance for extension of limitation suo motu writ petition, Honorable Supreme Court of India on 10th of July 2020 categorically observed that service of notice, summons and exchange of pleadings is a requirement of virtually every legal proceedings. Service of notice, summons and pleadings have not been possible during the period of lockdown because this involves visit to post office, courier companies or physical delivery of notice, summons and pleadings. Therefore, Honorable Supreme Court deemed fit to direct that such services of all the above may be effected by email, fax, commonly used as instant messaging service such as WhatsApp, Telegram or Signal. However, if a party intends to effect service by means of said instant messaging services, in addition thereto, the party must also effect service of the same document by email simultaneously on the same date. It was in view of the directions issued by Honorable Supreme Court of India that in the case of Seema Bhatnagar versus Anup Sharma, the case which Honorable Justice Mr. Monga was also referring to, Honorable Punjab and Haryana High Court in the year 2021 for procuring the service of the respondent in the revision pertaining to domestic violence case allowed the prayer of the counsel for the petitioner who sought directions to effect service upon the respondents by email and WhatsApp. The court, while allowing the application, directed the party that he would furnish an affidavit to the effect that email and WhatsApp numbers were correct and that email sent has not bounced back as well, to take a screenshot of the service of the summons through WhatsApp upon both the respondents. Lately, I checked the status of this case and I found that both the respondents had appeared before Honorable High Court in view of the service made through WhatsApp, and now the case was fixed for filing of reply. So far as affecting the service of a person involved in a criminal proceedings is concerned, vis-a-vis section 125 CRPC or section 340 CRPC by way of WhatsApp or email, it is still a grey area for want of any provision in CRPC. In the case of Anup Jacob versus State of Kerala in the year 2021, Honorable Kerala High Court, while answering in negative to the question as to whether the service to the accused by way of WhatsApp is an accepted mode of service, held that there is no provisions in CRPC for effecting the service of the party other than section 91 to section 90 CRPC, and WhatsApp cannot be used for affecting the service of the person. Further, there are still challenges so far the service of the summons are concerned. The foremost challenge is the absence of clear guidelines, clear rules in the procedural law with regard to the adoption of service of summons either through SMS or email or instant messenger service like Telegram or WhatsApp. Also, no doubt there is a presumption under section 88 of Indian Evidence Act, which is attached to electronic message, but the presumption is not with regard to the person by whom such a message was delivered for transmission. Further, there is a challenge of spoof mail or temporary emails, social engineering attacks like phishing, clickjacking, baiting or spamming, and in worst case scenario, hacking can also not be ignored. Now, during the course of arguments in the case before Honorable Supreme Court in reference cognizance for extension of limitation, a bench of the then Honorable Chief Justice S.A. Bobde and Honorable Justice Reddy and Honorable Justice A.S. Bopanna agreed with the suggestions of Attorney General K.K. Venugopal and Solicitor General Tushar Mehta that service of summons and notices through emails would constitute a valid delivery of the legal instruments, asking the respondent or person to either appear before the court or respond to a court query. It was said that innovation was needed as physical delivery of the notice or summons during lockdown period has been difficult. However, Attorney General Venugopal expressed a reservation about service through WhatsApp since the messenger service claims that it is end-to-end encrypted. It would be difficult to prove the legitimate service of summons or notice sent through WhatsApp. To this reservation, the then Honorable Chief Justice of India inquired that if the notice sent to summons in message form reflects 2 blue ticks, then it would constitute as valid service. However, Solicitor General Tushar Mehta pointed out that it is easy to tweak the WhatsApp settings to not to show the sender the blue ticks. This would give an enormous impression that the person has not received the summons despite him receiving and going through it. Hence, this is one of the biggest challenges that we may face with regard to the summons of parties through WhatsApp in our family justice system. Now, there are certain other challenges that we have to see at the time of service of process. We also received a lot of queries with regard to the service of persons who are residing abroad as to how to procure their service in matrimonial proceedings. Yesterday, some of these provisions had been covered by Shri Hemraj Mittal, Learned Principal Judge, Family Court, Fatehabad, in his presentation. However, to add to the same, on the criminal side, we have Section 105 CRPC, which provides for reciprocal arrangements regarding the service of process. Now, India has entered Mutual Legal Assistance Treaty arrangement with 39 countries. Due to entering such MLAT, the said country has the obligation to reciprocate with serving of notice and summons to the person residing in that country. In view of the directions given by Honorable Bombay High Court in Mr. Nimish Harkishan Das Topiwala, comprehensive guidelines regarding service of summons, notices, judicial processes on the person residing abroad, so issued in the year 2007 by Ministry of Home Affairs, were recirculated in the year 2017 to all the learned registrar generals of all the Honorable High Courts of India. Entire procedure has been laid down in those guidelines to effect the service of such persons in criminal cases who are residing abroad. However, it would be worthwhile to mention that the guidelines can be used for serving the summons in criminal cases only, and warrants will not be entertained as it amounts to extradition of the individual. Furthermore, another point that I would like to bring to the notice of this esteemed audience is that the countries with whom India has not created mutual legal assistance treaty, there is an assurance of reciprocity with that country. Now, the difference between the two is that the country with which MLAT is entered is duty bound to effect the service of the person residing in that country, but with the country with whom no such treaty was entered is not duty bound to get the service of the person residing abroad. Now, so far the service of the persons residing abroad in civil matters are concerned, Order 5, Rule 26 and Order 5, Rule 26A CPC deal with the service in foreign territory through political agent or court and the summons to be sent to the officers of foreign countries. Also, there is Hague Convention on the service abroad of judicial and extrajudicial documents in civil or commercial matters 1965. India became signatory in the convention on 23rd of November 2006 and its provisions were entered into force on 1st of August 2007. In view of convention, now the summons to the persons residing abroad in civil proceedings, which includes matrimonial proceedings, can be sent to those countries who are signatory to the convention. Although it's a very time-consuming process, but the advantage of using this mode of service is that now where the summons was served to the person residing abroad or that country, the judgment passed would also be enforceable in that country. Other than the provisions in Criminal Procedure Code as well as Civil Procedure Code, resort can be taken of Section 10, subsection 3 of Passport Act. Now, Section 10 speaks with regard to variation, impounding and revocation of passports and travel documents. Under Clause E and H of subsection 3 of Section 10 state that if it is brought to the notice of the passport authority that warrant or summons for the appearance or a warrant for the arrest of the holder of the passport or travel document has been issued by a court under any law for the time being in force, or if an order prohibiting the departure from India of the holder of the passport or other travel document has been made by any such court, and the passport authority is satisfied that a warrant or summons has been so issued or an order has been so made, the passport authority may impound or cause to be impounded or revoke a passport or travel document. Now, the constitutional validity of this provision was upheld on the touchstone of Article 14, 19 and 21 of the Constitution of India in the case of Rajiv Tayal versus Union of India by Honorable Delhi High Court. Therefore, so far service of persons residing abroad are concerned, we can take the resort to Passport Act, the provisions under CRPC, MLAT provisions, while in CPC, we can take the resort of Hague Convention, to which India is also a signatory. Now, I shall take the second part of my presentation, which is pertaining to the admissibility of the electronic evidence in family justice system and the challenges thereof. Now, as we all know that Section 3 of Indian Evidence Act speaks about the evidence, and it also means documents, including electronic records produced for the inspection of the court. We do not have any specific definition of electronic evidence other than which are given or are being used by the international organizations, that it is an information of probative value that is stored or transmitted in binary form that may be relied upon in the court of law. Now, coming back to Section 3 of Evidence Act, the expression electronic record, electronic form, information shall have the meaning respectively assigned to them in the Information Technology Act 2000. Section 2T and 2R of IT Act give out the definition of electronic record and electronic form, which means data record or data generated, image or sound recorded, received or sent in an electronic form or microfilm, etc. It has now been a settled law that electronic record is a document only, as held by Honorable Supreme Court in the case of P. Gopal Krishnan in the year 2018. Now, what kind of electronic evidence are we looking for as produced before the family court? It can be a cell phone or a mobile phone, computer or laptop, digital audio or video files, CCTV footage, call detail records, internet browser history, social media posts, social media chats, and the list is endless. Now, before dealing with the electronic evidence, there are certain provisions that are pertinent in dealing with such kind of evidence before the family court. Section 13 of the Family Courts Act speaks with regard to the right to legal representation, that no party is entitled to be represented by the lawyer as a right before the family court, provided if the family court considers it necessary in the interest of justice, it may seek the assistance of a legal expert or amicus curiae. Section 14 empowers the court, family court, to receive and admit the evidence as produced before the court that may, in its opinion, assist it to deal effectually with a dispute whether or not the same would be otherwise relevant or admissible under the Indian Evidence Act. While Section 20 gives the overriding effect of the Family Court Act 1984 over any other law which is inconsistent with the spirit of the Act. Now, keeping all these provisions in mind, now let us take up the first issue with regard to the admissibility of electronic record. Now, the general rule with regard to the admissibility of electronic evidence is now more or less settled, that the secondary electronic evidence can be produced before the court with a certificate under Section 65B, which was also held in the case of Arjun Pandita Rao in the year 2020. Now the question is as to whether the certificate under section 65B is required for admitting such electronic record before the family court. For that, the object of the Act, as stated in clause H of the statements of objects and reasons, is required to be looked into, that it is to simplify the rules of evidence and procedure so as to enable the family court to deal effectively with a dispute. It is to remove an embargo on the family court to first examine the relevancy or admissibility of the document under the Indian Evidence Act in considering such document in adjudication of a matrimonial dispute. Now, in the case of Dipali Santosh Lokhande, Honorable Bombay High Court categorically held in the year 2018 that if there is any electronic record for which certificate under section 65B of the Indian Evidence Act is necessary, it would not preclude the learned judge of the family court to exhibit such document in evidence, forming an opinion as to whether the document should assist the court to deal effectively with the dispute in hand. In the case of Preeti Jain versus Kunal Jain in the year 2016 by Honorable Rajasthan High Court, in the case of Dipali Santosh Lokhande versus Santosh Vasantrao Lokhande in the year 2018 by Honorable Bombay High Court, and in case of Dipti Kapoor versus Kunal Julka in the year 2020 by Honorable Delhi High Court, it was unanimously held that Section 14 read with Section 20 of Family Court Act eclipse Section 65B of Indian Evidence Act, which means that if the secondary evidence is to be produced in the shape of a printout or a mobile recording in a pen drive or a CCTV footage in a CD, then certificate under Section 65B is not required. Now, let me take you to another issue which the family court face, that is with regard to the illegal procuring of such electronic evidence and to be produced before the family court. Now, the general rule with regard to illegal procuring of the evidence is that even if the evidence is illegally obtained, it is admissible. Merely because a search or seizure was illegally conducted and may amount to breach of a fundamental right, that would not make search or seizure invalid in law. This was held from the earliest case of Regina versus Maqsood Ali and now also in the case of Yashwant Singh versus CBI through its director in the year 2019. However, we have an important fundamental right looming over such evidence procured illegally, and that is the right to privacy, which has now been recognized not only against the state, but also against the non-state actors, starting from People's Union for Civil Liberties versus Union of India in the year 1997, famous as phone tapping case, and finally held in the case of Justice Puttaswamy versus Union of India in the year 2017. Now it is to be seen as to whether the fundamental right to privacy is infringed with illegal procuring in evidence in family cases. This issue has cropped up many a times before the courts in the case of Dipender Singh Maan versus Ranjit Kaur, Srimati Rayala M. Bhuvneshwari versus Napapinder Rayala in 2007, Vishal Kaushik versus Family Court and another in the year 2015, Anurima alias Abha Mehta versus Sunil Mehta in the year 2016, and Dipti Kapoor versus Kunal Julka in the year 2020, that whether the act of recording the conversation without the knowledge of the wife is illegal and amounts to infringement to the right to privacy. Now, in the case of Dipti Kapoor, Honorable Delhi High Court categorically held that in Puttaswamy case, the 9 judges bench, Constitution bench of the Supreme Court has not dealt with the law and principles of evidence in the context of the right to privacy. Further, it was held in Puttaswamy case that right to privacy is a fundamental right, but it is not an absolute right. Hence, in the case of Dipti Kapoor versus Kunal Julka, Honorable Delhi High Court laid down legal landscape with regard to the admissibility of electronic evidence procured illegally in family case. It was held that purely from the standpoint of the law of evidence, such evidence is admissible so long as it is relevant regardless of how it is collected. Digressing from the settled position would have wide ramifications and consequences and would be a serious hindrance to judicial proceedings across the board in several foreseeable and unforeseeable ways. It was also held that mere admitting the evidence on record is not a proof of fact in issue or a relevant fact. It is mere inclusion of evidence in the records to be assessed on the comprehensive set of factors, parameters, aspects in the discretion of the court. In view of the breadth of power conferred on family court under Section 14 of the Family Court Act, it was laid down that even though a given piece of evidence may have been admitted on record, the family court must be extremely circumspect in what evidence it chooses to rely upon in deciding the dispute, particularly the authenticity and genuineness of the evidence, for which stringent standards must be implied. It was also held that if, in the opinion, the nature of the evidence sought to be adduced is inappropriate, embarrassing, or otherwise sensitive in nature for any of the litigating parties, or for that matter, for some other person not directly connected with the litigation, the court may restrict the parties present in the court at the time of considering such evidence, or may conduct in-camera proceedings so as to not to cause distress to any person or party, while at the same time not hesitating to receive evidence that the family court considers necessary for effectively deciding the dispute. All the proceedings must be conducted strictly within the bounds of decency and propriety, and no opportunity should be given to any party to create a spectacle in the guise of producing evidence. Also, in egregious cases, the family court may initiate direct initiation of legal action against litigating party or other person who may appear guilty of procuring evidence by illegal means. However, we have a contrary view of our own Honorable High Court in the case of Neha versus Vibhor Garg in the year 2021, in which husband had illegally procured the evidence of his wife by installing a recorder in the bedroom and hence producing that evidence before the court. Our Honorable High Court, taking the right to privacy as a fundamental right, as held in the case of People's Union for Civil Liberties case, held that such illegally procuring the evidence without the consent of the wife is an infringement to right to privacy, and that evidence cannot be made admissible before the family court. The said authority is now under consideration before Honorable Supreme Court of India, and we are awaiting the decision of Honorable Supreme Court on this aspect. Now, other challenges which I could foresee that the electronic evidence may produce before the family courts are with regard to the admissibility versus authenticity of such evidence. Now, in the case of R.M. Malkhani versus State of Maharashtra, it was categorically held by Honorable Supreme Court that a contemporaneous tape record is admissible under Section 8(1) if conversation is relevant to the matter in issue. Second, There is identification of voice. Third, the accuracy of the tape recorded conversation is proved by eliminating the possibility of erasing tape record. Now, in the era of digital technology, where such kind of volatile electronic records are being produced either in the shape of CCTV footage or audio or video digital files, or secondary evidence in the shape of social media posts or in the form of printouts, can the same yardsticks as given in the case of R.M. Malkhani be applied with regard to establishing the genuineness or authenticity of the electronic evidence? Now, under Section 45A of the Indian Evidence Act, it is the opinion of the electronic examiner qua authenticity of the electronic record so produced which is relevant. Section 45A speaks with regard to the electronic examiner so appointed under Section 79 of Information Technology Act. At present, we have only 9 certified laboratories across India which can prove the authenticity of electronic record. Hence, the question before the family court can be that can the authenticity of the electronic record produced before the court be proved by any other private lab or any other lab which is not notified by the central government? Then the other issue that came into my mind while I was preparing this presentation was with regard to the admissibility of the electronic evidence. Now, it has been held under Section 65B that no certificate is required where secondary evidence is being produced before family court. Now, Section 4 of Information Technology Act provides for legal recognition of electronic records, and Section 7 of Information Technology Act provides for retention of electronic records. Earlier, with the implication under Section 65B, along with the secondary evidence of the electronic record, Section 4 and Section 7 of Information Technology Act were not applicable. Now the question is that where Section 14 of the Family Act 1984 eclipses the requirement of Section 65B of Indian Evidence Act with the secondary evidence, whether the electronic record in the secondary form would be legally recognized, whether the party producing the secondary evidence of the electronic record is duty bound to retain and preserve the original record for subsequent reference, whether Section 20 of the Family Court Act would override Section 81 of the Information Technology Act. Question also arises with regard to the preservation of such electronic records, either primary or secondary, when produced before the court and later on its disposal. Now, I would also like to bring to your kind notice the other developments that are happening in the world of digital technology that we all should be aware of. Most recently, I read that a marriage was registered by using the blockchain technology. Now, what would be the validity and the legality of such marriages if started happening in future? Now, there was an article in the year 2015 that will the drones be the next tool spouses used to spy? Now, if the evidence is collected by way of drones without any human intervention, what will be the nature of such evidence before the court of law? Would there be a clear-cut infringement of right to privacy, especially when such evidence is collected unintentionally by the third party? Can any legal action be taken against the third party? Would drones be a security threat due to their potential uses as a tool for snooping and surveillance? Now, where the evidence are collected through hacking or spyware or GPRS, what would be the nature of such evidence in the eyes of law? What would be the penal consequences as well as the civil damages? Now, where the entire objective of the Family Court Act is to provide for the establishment of family courts with a view to promote conciliation and secure speedy settlement of disputes relating to marriage and family affairs and for matters connected therewith, taking a penal action against the guilty party either by the aggrieved party or by the family court, would fulfill the objective of that Family Court Act? These are certain questions that we as judges in the era of digital technology require to ponder upon. And now I take you to the world of audio video conferencing vis-a-vis family justice system. Now I vividly remember the time, and I'm sure you too agree with me as to how we used to book a trunk call to speak to our nears and dears ones, standing in queue for hours just to speak for a couple of minutes, with eyes always on the meter, with the telephone operator giving this disdained look, and the person behind us waiting impatiently, tapping his foot to give us the clue to finish that call. And now, welcome to this millennia, where we not only speak, but see, not for minutes, but for hours, with our nears and dear ones on the data calls through software application. I welcome you all to this new small world where distances have lost its much significance. Welcome to the era of audio and video conferencing. So of course, video conferencing is a live video based meeting between two or more people in different locations. It is a platform to meet people and collaborate face to face from long distance by transmitting audio, video, text through internet. No doubt, it saves time, it's cost effective, it reduces hassles associated with traveling, it is easy to connect, it improves communication, it increases efficiency and productivity. And with global COVID-19 pandemic, video conferencing saw a huge boost. Now, whether the audio video link in the matter of evidence is permissible in law or not came for consideration for the first time in the case of 20th Century Fox Film Limited versus NRI Film Production Associates Private Limited before Honorable Karnataka High Court in the year 2003. Honorable Karnataka High Court interpreted the word attendance as used under Order 18, Rule 3, Sub-Rule 4, 2, that the attendance is to be understood as the person being present, and it need not be a physical presence. The presence on the screen is as good as attendance for the purpose of Order 18, Rule 3. After all, law only requires the presence of the witness, and it does not matter how it is present. In the same year, celebrated authority of State of Maharashtra versus Praful B. Desai by Honorable Supreme Court came, where Honorable Supreme Court interpreted the word presence to meet the requirement under Section 273 CRPC. It was held that it is clear that so long as the accused or his pleader are present when evidence is recorded by video conferencing, that evidence in the presence of the accused, it would fully meet the requirement of Section 273 CRPC. Recording of such evidence would be as per procedure established by law. Now, in this beautiful authority, a distinction was made by Honorable Supreme Court between virtual reality and video conferencing. It was observed by Honorable Supreme Court that virtual reality is a state where one is made to feel, hear, or imagine what does not really exist. In virtual reality, one can be made to feel cold when one is sitting in a hot room. One can be made to hear the sound of ocean when one is sitting in the mountains. One can be made to imagine that he is taking part in the Grand Prix race while one is relaxing on one sofa. And nowadays, if I may say, that the new word for virtual reality is metaverse. Now, continuing further, video conferencing has nothing to do with the virtual reality. Advances in sciences and technology have now, so to say, shrunk the world. It enables people to see and hear events taking place far away as they are actually taking place. For example, One does not need to go to South Africa to watch World Cup matches. One can watch the game live as it is going on TV. If a person is sitting in the stadium and watching the match is being played in his sight or presence, and he or she is in the presence of players. This is not virtual reality. It is actual reality. One is actually seeing and hearing what is happening. Now, in the family law system, video conferencing was first ordered to be used in the case of Amitabh Bagchi versus Ina Bagchi in the year 2005, where the question before Honorable Calcutta High Court was whether a witness can be examined by way of video conferencing in a divorce case under Hindu Marriage Act. Honorable Calcutta High Court, while placing reliance upon Prafulla B. Desai and 20th Century Fox judgments, held that if the law courts do not permit the technology development in the court proceedings, it would be lagging behind as compared to the other sectors. Technology is definitely a tool. Not only this, in this case, Honorable Calcutta High Court laid down certain guidelines and safeguards as to how such evidence can be recorded through video conferencing. Now, in a transfer proceeding before Honorable Supreme Court, the question posed in the case of Krishna Vini Nigam versus Harish Nigam in the year 2017 was that whether there can be any alternative to transfer of proceedings to suit convenience of both the parties and also to serve the ends of justice. Can video conferencing be an alternative mode for conducting the matrimonial or custody matters wherever defendants or respondents are located outside jurisdiction of court? While answering the said questions, Honorable Supreme Court incorporated in the interest of justice certain safeguards for ensuring the summoning of defendant or respondent should not result in denial of justice with respect to the cases where the proceedings between the parties to a marriage or arising out of dispute between the parties to the marriage wherever the defendant or respondents are located outside the jurisdiction of the court. Now, one of the safeguards was with regard to the availability of the video conferencing facility, and it was also ordered that email address or phone number, if any, at which litigant from outstation may communicate also be incorporated in the order along with the summons. However, in the case of Santini versus Vijay Prakash in the year 2018, the question posed and referred to larger bench was whether the parties can be directed to avail the facility of video conferencing in view of the provisions of the Family Court Act 1984, Hindu Marriage Act 1955, and the Civil Procedure Code. 3 judges bench of Honorable Supreme Court in the year 2018 with the majority of 2 judges held that video conferencing in absence of consent of other parties held would be contrary to Section 11. Once the settlement fails and if both the parties give consent that a witness can be examined in video conferencing, that can be allowed. That apart, when they give consent that it is necessary in a specific factual matrix having regard to the convenience of the parties, the family court may allow the prayer for video conferencing. An addendum was made that a joint application should be filed before the family judge and shall take a decision in that regard. However, the facility of video conferencing in family law system can be used for other purposes. One of the purposes would be with regard to recording of statements under Section 13B, subsection 2 of Hindu Marriage Act 1955. Now, in the case of Amardeep Singh versus Harveen Kaur in the year 2017, it was held by Honorable Supreme Court that appearance through video conferencing of close family can also be permitted if parties themselves cannot appear before the court due to good and valid reasons for recording the statements before the family court. The law laid down in the case of Amardeep Singh was later on followed by courts, and it was reiterated by our own Honorable High Court in the case of Balwinder Singh versus Suman Rani alias Suman Lata in the year 2019. That apart, the video conferencing can also be used for visitation rights. Now, during pandemic, one of the problems that arose for the parties involved in the litigation in the family court was with regard to the accessibility of the child by the other parent for meeting. A writ petition in that regard was filed as Tanush Dhawan versus court in its own motion, and Honorable Supreme Court on 30th of April 2020 observed that the grievance of the petitioner is that because of the lockdown, the children are unable to interact with the parents even though they have visitation rights for the purpose. If they have visitation rights, it was suggested that electronic contact instead of physical visits can be substituted in these times. The parties can arrive at a mutually acceptable arrangement in this behalf. If there is an aggrieved party, the same can approach the family court. Later on in the case of Madhurima Deepak Pant versus Deepak Lalit Prasad Pant by Honorable Bombay High Court, and in case of Firoz Khan versus Shaheen Praveen Khan by Honorable Chhattisgarh High Court, and also by other high courts, similar directions were issued with regard to the usage of video conferencing for the visitation right by one set of the parent to the other to have access of the child through electronic contact. Now, with regard to the registration of the marriage, now recently in the case of Ami Ranjan and another versus state of Haryana in the year 2021, the question before our Honorable High Court was whether the parties can be permitted to appear through video conferencing for registration of marriage before the registrar, to which Honorable Punjab and Haryana High Court held that the personal appearance of the parties to the marriage can be dispensed with by the local registrar. It was further observed that the local registrar is empowered to obtain the personal appearance to video conferencing. Now, talking about the specific rules concerning video conferencing. Now, in the year 2018, video conferencing guidelines for the conduct of court proceedings between courts and remote sites and the VC facilities set up at other places in the state of Punjab, Haryana and UT Chandigarh were framed by Honorable Punjab and Haryana High Court. Now, during COVID-19 pandemic, directions by Honorable Supreme Court in reference guidelines for court functioning through video conferencing COVID-19 pandemic suo motu civil writ petition number 5 of 2020 dated 6th of April 2020. One of the directions issued was that until appropriate rules are framed by the high courts, video conferencing shall be mainly employed for hearing the arguments, whether at the trial stage or at the appellate stage. In no case shall evidence be recorded without the mutual consent of both the parties by video conferencing. If it is necessary to record evidence in a courtroom, the presiding officer shall ensure that the appropriate distance is maintained between any two individuals in the court. Thereafter, as we all know, that we received model rules on video conferencing from Honorable Supreme Court of India in the year 2020. Now, in consequent to these rules, while order dated 26th of October 2020, in the same writ petition, Honorable Supreme Court observed, proposed to substitute subpara 7 of paragraph 6 with the following: the video conferencing in every high court and within the jurisdiction of every high court shall be conducted according to the rules for that purpose framed by that High Court. The rules will govern video conferencing in the High Court and in the district courts and shall cover appellate proceedings as well as trials. We are given to understand that several High Courts have framed the rules already. Those High Courts that have not framed the rules shall do so, having regard to the circumstances prevailing in the state. Till such rules are framed, the High Court may adopt the model video conferencing rules provided by the E-Committee, Supreme Court of India, to all the Chief Justices of the High Court. Now, recently, after the model rules on video conferencing were received, in the case of Sumati Gulati versus Pratik Bajaj, decided on 29th of April 2021 by Honorable Punjab and Haryana High Court, the petitioner filed a revision petition for setting aside order passed by Family Court, whereby application filed by the petitioner under Section 151 CPC seeking physical appearance of the witness sought to be examined by the respondent husband in his petition under Section 13 of Hindu Marriage Act and not proceeding with the examination of the petitioner's witnesses through video conferencing has been dismissed. Now, while dismissing the revision, Honorable High Court observed that rules regarding video conferencing have not been notified by High Court, though guidelines had been issued in the year 2018 itself. The Honorable Supreme Court has also issued various directions. Model video conferencing rules have also been circulated. Hence, it was directed that the examination of the respondent be carried out by the trial court while adhering to the guidelines as circulated in 2018, as well as the model video conferencing rules circulated by Honorable Supreme Court. Trial court was also directed to ensure appointment of the remote point coordinator and adherence to the procedure as provided in terms of the said guidelines or model rules. In case any deviation is required to be made from the model rules to ensure sanctity of the testimony to be recorded and keeping in view any exigency, trial court shall record specific reasons for the same. Now, last year in December 2021, video conferencing rules as Part H, Chapter 1 of the Rules and Orders of Punjab and Haryana High Court, Volume 5, were finally incorporated and adopted. Now, if we have a perusal of those rules, it consists of 5 chapters with 19 rules intact in it, along with 2 schedules. Schedule 1 speaks with regard to the protocol to be adopted during video conferencing, and Schedule 2 speaks with regard to the request form for video conferencing. Now, Rule 1 speaks that the rules shall apply to such courts or proceedings or classes of courts or proceedings and from date as the High Court may notify in the behalf. These rules shall come into force with effect from the date of notification. Now, whether the said rules would be applicable to family courts or not would some changes be required in the said rules with regard to the recording of evidence of the party through video conferencing in view of the law laid down in the case of Santani Nagam by Honorable Supreme Court is now yet to be seen. Now, concluding my session, I would say that any implementation of new technology will have initial hiccups. These hiccups are to be removed by proper application of law with sufficient safeguards. Digital technology is here not only to stay, but thrive to its full blooming effect. Family law system cannot be left behind, because emotions are involved or social fabric of the society is to be maintained. Now, I remember that in the early months of lockdown, I got the opportunity to read a beautiful book, A Brief History of Homo Sapiens by Yuval Noah Harari, where he traced the history of humans from prehistoric era till now. And he proposed that if we have to walk hand in hand or supersede technology, which is the brainchild of human, we need to acquire 2 skills. emotional intelligence, that is adoption to technology, and mental balance, that is to encourage and understand the change. And I must say that we as judges are not only trained to have those skills, but we have the skills to amalgamate the intelligence and the mental balance with the human emotions that we see in the family justice system by laying down more and more emphasis on the amicable solution of the matrimonial acrimony between the parties with the best and optimum use of the digital technology. Thank you very much for such a patient and lovely hearing. Namaskar.
Thank you, Harshali. You know, it was such a smooth go. I'm very happy with your presentation. Thank you so much for working hard on it and showing us the roadmap in this particular direction relating to the family court matters. With this session comes to an end, and we are now in for the next session. Thank you so much.
Thank you, sir.
Sir, welcome.
Thank you, Doctor. Thank you, sir.
You know, this 2 days workshop relating to the family court matters, we come to a close to that. In my opening remarks for this particular workshop, what I said was the challenge is to build up happy homes, happy families, happy children. The effort has been made in different sessions towards that particular direction. In this valedictory session, we have with us Justice Amol Rattan Singh, Judge, Punjab and Haryana High Court, and President Board of Governors, Chandigarh Judicial Academy. Sir, most welcome for the valedictory address. My Lord had joined the bar in the year 1985. He was elevated in the year 2012. The bar years were highly contributory. In fact, he was, from the year 2005 to 2012, the Additional Advocate General Punjab. I'm conscious myself was at the bar at that particular point of time. The kind of contribution that Justice Singh had made, we still remember that. And thereafter, after having been elevated, the kind of contribution that you have made, we feel proud of that. I'm happy to request you to kindly deliver the valedictory address in the context of this 2 days workshop on family court matters. Over to Justice Singh.
Thank you so much, Dr. Gupta. I don't know whether the contribution has been that much, as you've been very gracious to say. All of us do our job. All of us deal with whatever comes before us to the best of our ability. And my colleagues, myself, all members of the bar, everybody puts in his might to the whole judicial system. And, well, it goes on, as it has for the past, well, at least since the Constitution, and before that the precursor courts, and as it will, God willing, till there's no need for lawyers and judges. I wonder when we'll reach that stage of society. But thank you so much. Dr. Gupta, Director Academics, Ms. Shalini Nagpal, Director Administration, Chandigarh Judicial Academy, all other learned judicial officers present. I don't think I can add much or anything at all to what Dr. Gupta must have already told you at the beginning of the session yesterday, and what all resource persons and other judges before me have also already spoken about on the issue. And in that context, before I say anything else, I'd like to thank all the honorable judges, my colleagues who came here to address this seminar. Justice Ritu Bahari, Justice Anupinder Singh Garewal, Justice Arun Monga, Justice Meenakshi Mehta, Justice Vivek Puri, and Justice Vikas Behel. As also all the resource persons, other than Dr. Gupta and Mrs. Shalini Nagpal, of course. That started with Ms. Ritu Tagore, District Concession Judge, cum Principal Judge, Family Court, Ambala, Ms. Sangeeta Rai Sachdev, Additional Session District Concession Judge, and Additional Judge, Family Court, Ambala, Ms. Madhu Khanna Lali, Additional District Judge, cum faculty member of the CJA, Mr. Anil Malhotra, advocate and author, and a very old associate, Mr. Hemraj Mittal, Principal Judge, Family Court, Fatehbad, Mr. Dr. Sudhir Kumar Jain, Judge Trainer, who's come from Delhi, all the way from Delhi to address this seminar. Ms. Arzu Gupta, Assistant Professor, Clinical Psychology, Department of Psychiatry, Government Medical College and Hospital, Sector 32, Chandigarh. Again, of course, Ms. Madhu Khanna and Mr. Malhotra addressed 2 sessions. Then Ms. Harshali Chowdhary, Additional District Session Judge, cum faculty member of the Academy. Thank you all very much for coming here to address all honorable judges of Punjab and Haryana. I'm sure there's nothing, as I said, nothing I can really add to what must have already been said over these past 2 days, and by all members, all who addressed this gathering. As we all know, family issues have become more pronounced in the past, I would say, couple of decades. Thank God, so far at least, we are not we are still one of the countries which has a low divorce rate. But nonetheless, just the size of our population itself does not actually show that the numbers, if they are taken, would be lesser than other countries. It's only in terms of percentage to the total population that we are probably much lower. But unfortunately enough, litigation pertaining to this branch of law has multiplied to levels where it should not have. But anyway, society is still evolving. We still have to leave, all of us individually and collectively have to reach far higher levels of maturity than we have before we can actually come to a, how should I put it, a non-conflicting society, which is, of course, a form of utopia, not anywhere in the horizon in the near future. Hopefully not in the too distant future, but that's, of course, to be seen. So therefore, all of you are obviously fully aware of the responsibility on your shoulders in dealing with such issues as come before you on a day-to-day basis, whether it's child custody, whether it is relationships within the family, husband and wife, of course, being the prime source of conflict, unfortunately, in this kind of litigation. And of course, also other related issues like domestic violence and senior citizens having issues with the younger members of the family, etc. All of which naturally has to be dealt with very, very sensitively and in a manner empathizing, or not in a manner, actually empathizing with the litigants on both sides. And thereafter coming to a conclusion, as per the evidence before you in all forms, as to which side is correct or incorrect, or whether each person in her or his own right would be right, and therefore temperamental differences, which of course is one of the large issues which has come up in the past couple of decades, other than, of course, the prime issue being economics. But well, that's how society is placed at the moment, until we actually reach a level where we can transcend such kind of differences amicably. The burden falls on all of us as judicial officers and judges, effectively all judges, to deal with the matter, all matters coming before us, in a sensitive and empathizing manner, after, of course, due application of mind as per the law applicable. So, with all of you obviously aware of that responsibility, I would just like to say that please, every job gets monotonous at some point of time and at time and again. But such monotony cannot make us complacent as regards the responsibility we owe the litigants before us. And each case, for us, may be another case as it is, because we are dealing with so many on a daily basis, from morn to eve. But for each litigant, it is a question of a lifetime. So no matter how monotonous any cases, any issues might become before you, you need to pull yourself out of, we all, rather, I won't say you, all of us, we all go through it. All of us need to pull ourselves out of that complacency, that monotony, and deal with the matter before us as if it is, each case is which it is, of course. Each case is an individual or a couple of or set of individuals whose conflict, whose problems need to be resolved by us as per the responsibility cast upon us. If on any particular day it becomes too much, that which becomes every day, in fact, that towards the end of the day, all of us are mentally so tired, we're not able to possibly apply our minds as we had in at the beginning of the day or even during the course of the day. Put it off for another day. Don't get rid of it just because we are mentally tired at that point of time, or we have reached a stage of complacency due to monotony, etc. Put it off another day, but do not dispose it off with a lethargic or a tired mind. That is my sincere endeavor and sincere plea to all of you, which I'm sure you're all aware of. It's just sometimes things have to be reiterated by somebody older. And I'm sure, other than Dr. Gupta, I'm probably the oldest person here. So kindly bear that in mind. And I'm sure all of you are doing your jobs to the best of your ability, which is, of course, no mean feat at all. And wishing you all the very best in your careers, in your day-to-day work and work and your personal lives. All the best. God bless you all. Thank you.
Thank you so much, Justice Singh. Your message is loud and clear. The monotony has to be broken, and that every effort must be made, and the case is not to be killed because of the monotony as such. Thank you so much. May I now request Madam Shalini Singh Nagpal, our Director Administration, who has actually again piloted this particular workshop. We always admire her zeal to contribute more and more. May I now request you to kindly express the expression of gratitude to all those who have contributed to this workshop. Over to Madam Nagpal.
Very good afternoon to Honorable Mr. Justice Amol Rattan Singh, President of the Board of Governors, Chandigarh Judicial Academy, Dr. Balram K. Gupta, Director Academics, all resource persons, judicial officers of Punjab, Haryana and UT. On the successful culmination of the 2 days workshop on the Family Courts Act, I have the privilege to propose a vote of thanks and acknowledge the contribution of those who have worked so hard to make this workshop a reality and success. Such workshops do not happen overnight. The wheels must start moving at least 1 or 2 months in advance. It requires much planning and perseverance. Heartfelt gratitude to Honorable Ms. Justice Ritu Bahari, Honorable Mr. Justice Anupinder Singh Garewal, Honorable Mr. Justice Meenakshi I. Mehta, and Honorable Mr. Justice Vivek Puri, Chairperson and members of the Committee for Sensitization on Family Court Matters. Lordships have been our guiding lights, giving important insight into significant issues relating to family courts, and have also gracefully adorned the sessions with their valuable comments. I also thank Honorable Mr. Justice Arun Monga, Honorable Mr. Justice Vikas Bahel, judges Punjab and Haryana High Court, who so readily consented to being a part of the event. Thanks to all honorable judges for sharing their opinions. Our President, Honorable Mr. Justice Amol Rattan Singh, has always inspired us and encouraged us to do our best, and at the same time giving us freedom, complete freedom to do as we want. He stands firm as our pillar of strength. Many thanks to Honorable President who has spared his valuable time to grace the occasion. Sir, your words and action always propel us to move forward and improve our performance. Many thanks to our resource persons, Ms. Ritu Tagore, District and Session Judge, cum Principal Judge, Family Court, Ambala, Dr. Sudhir Kumar Jain, District and Session Judge, Delhi, Judge Trainer, Ms. Sangeeta Rai Sachdeva, Additional District and Session Judge, cum Additional Principal Judge, Family Court, Ambala, Ms. Madhu Khanna Lali, our faculty member, Shri Anil Malhotra, Advocate and Author, High Court of Punjab and Haryana, Mr. Hemraj Mittal, Principal Judge, Family Court, Fatehbad, Ms. Arzu Gupta, Assistant Professor, Clinical Psychology, Department of Psychiatry, GMCH Sector 32, Chandigarh, who worked tirelessly preparing these sessions. They enriched the sessions with their valuable experiences and made the workshop a success. We are supported by a team of active and dedicated faculty members who have put in much labor and efforts beyond their comfort zones. I would also like to thank Dr. Balram K. Gupta, Director Academics, for guiding us throughout, Ms. Harshali Chowdhary, ADJ-cum-Faculty member, Chandigarh Judicial Academy, for her well-coordinated efforts for the success of the workshop. The online workshop would never have been so smooth but for the people who have worked behind the scenes. Our technical team, comprising of Shri Aman Kumar, Shri Sukhwinder Singh, Shri Amarveer, and Shri Dirghayu, who have executed the program flawlessly. I would also like to extend my thanks to the principal judges, the additional principal judges, the family courts, all additional district session judges of the states of Punjab, Haryana, UT, for their valuable participation before and during the workshop. The officers who have registered and submitted their feedback forms would be given their certificates in due course. I hope the 2 days have been fruitful, educating, and enriching. Thank you.
We wind up.
Thank you, sir. Thank you very much, sir.
No, pleasure. It was a pleasure. Thank you.